What we'll do is we're going to design a trust, a couple of trusts, and then we're going to talk about who's in charge of those trusts. And if you're a married couple, as long as either one of you is around, you're in charge of the trust. Eventually, though, we get to the point where there are going to be trusts for kids, grandkids, whoever else you pick, and there's a few things that happen. Somebody has to do that stuff and create those different trusts. And getting back to your question, attorneys tend to do that set of paperwork. But then they turn the actual assets over to a trustee, whoever you've picked, who then takes the assets and does whatever they're supposed to do with them down the road.
The cost of dying is approximately 3 to 5% of your net worth, whether or not you have a living trust. Okay?
So her question was, doesn't it make more sense to have the attorney involved in managing it? California, the state bar doesn't like that. They don't like for us to create a document and say, hey, as soon as you become incapable of managing these assets yourself, I'm going to take over. Because the state bar worries that, well, now if I take those assets and pay for my kids' college, or if I do the wrong kind of thing, then it's attorneys who are taking a bad rap. So the state bar makes it really hard for us to step in and become the trustee. We can help. We can become an agent for the trustee, but the only way the state bar likes for attorneys to actually do the trust is if it's a family member or a friend or somebody where there's a normal kind of relationship. You wouldn't be surprised to find me involved because I knew that person.
What Mark has done is put a firm resume in. One of the benefits is Mark is with some top-notch attorneys in his firm, including even Charles Morris, who worked for 25 years for the IRS in the estate and gift tax area. So you can't get a better expertise if you're talking about taxation when it comes to trust. That's one. Two is that Mark has also developed an online estate plan called Practical Estate Planning. And if you want to do your own, I would recommend going to practicalplans.com, and he actually does review each one of your estate plans, and that costs approximately...
It's a third. It's $950 if you do it online.
If you want to do it online. So I would recommend that way over LegalZoom or any other national, because this is strictly geared to California, and California is completely different than all the other states. So try not to do it yourself.
Say it one more time, what's online?
Practical plans. Plans.com. Okay? He certifies that the above is true and correct, and I don't believe you sell insurance or annuities or anything else.
No.
Okay. Mark, it's all yours.
We're going to talk about the estate tax because its overall structure is the reason that trusts get designed the way they get designed. So if you understand the flow of the estate tax, these trusts are going to make a lot more sense to you. It'll also be a way for us to go back and think through what's the difference between a probate estate versus a taxable estate, because we'll get that. Okay, so the IRS tells us when somebody dies, and if you're single, it's when you die. If you're married, it's when your spouse dies. We have to go through this whole calculation. So the first thing we have to do is picture your gross estate. Your gross estate means anything you can think of. It's not gross like they've come to your house and decided you're a bad housekeeper. It's gross like everything you can think of, anything you have an interest in, the IRS wants to know about. So, your house, it's an obvious one, but your house. All your bank accounts, that's checking, that's savings, CDs, any other kind of checking account, bank account that you can think about. Any kind of investment account that you have at a non-bank, Merrill Lynch. It also includes, and this is where people get confused, it also includes life insurance. and it includes retirement plans. So, are there other assets that you guys have that aren't up here that we should put on here? Personal effects, yes.
Intellectual property?
Yep. Business holdings.
Loans to children?
Mm-hmm. Anything where people owe you money. So any kind of receivable. Yes, ma'am.
Art, antiques, and collectibles.
Yeah. Art and collectibles. I know you said antiques too, but I don't have enough room. Okay, any other assets?
Asset in foreign country?
Foreign countries, yeah.
Cars.
Foreign assets, cars,
Jewelry. Invested properties.
very good one. Real estate, any other real estate? Okay, that looks pretty good. I don't see any more hands. So, now let's talk about which one of these. So the IRS wants all of these in your gross estate, the value of every one of these. So on the day that you die, we're supposed to get a snapshot. And for assets that aren't easily valuable, there's not a statement that says, what's today? On April 25th, the value is the following. We can kind of get to that with bank accounts and investment accounts and even retirement plans, right? But we can't really get to that with anything else. So part of the process we have to do is we have to get appraisals. We have to figure out values for all of these pieces of property and all these other different types of property. Personal effects, jewelry, art, collectibles, those kind of things, the IRS rule about those is that if you have one thing that's worth more than $3,000, you're supposed to get it appraised. And if you have a collection of things, like stamps or guns or belt buckles or whatever it is, and if that collection's worth more than $10,000, you're supposed to get that collection appraised. The only way the IRS knows about these things these days is if you've got them insured somewhere. So if you have a personal property rider on your homeowner's insurance and you've got all these items listed, the IRS asks you, or right up front, if they start to ask questions, did you have any insurance and what was on the schedules? So, and unfortunately we can't use those values on the schedules either for appraisal purposes unless you've got them appraised. Because otherwise it's just your guess at what it's worth.
And most individuals overappraise versus underappraise. So,
now let's talk about which one of these, it's a test, is actually part of your probate estate. So let's assume that you've got a trust and you've titled your assets in your trust. Okay? So your house, that's going to be in your trust, right? So if it's in your trust, it's not a probate asset. Okay? Bank accounts, they're in your trust, not a probate asset, right? Because you've got them in your trust. Your bank knows who's going to take over. Investment accounts, same thing. Now how about retirement and life insurance plans? Can you put your own IRA in your trust? No. You can't. The only thing you can do is designate a beneficiary. You can designate your spouse, you can designate your kids, you can designate any charity, you can designate anybody you want. But that's how these that's how this one passes. Same thing as life insurance. If the life insurance company decides that something's wrong with your beneficiary designation, they're going to disregard it. And they're going to say, the only way we're going to pay this is when you go to court and you get us a court order telling us who to turn these assets over to. So these two are very potentially going to be possibly in a probate estate.
Did you happen to read the article? John Hancock just settled a lawsuit here in the state of California for $20 million. And the reason for the lawsuit is exactly what he was just talking about. And that is the life insurance companies did not make a diligent effort to try to find the beneficiaries. And they were eating up the accounts in fees. So I would recommend that you go on unclaimed properties in the state of California And in the next month or two, you may be lucky enough to find out that some distant relative may have included you on a life insurance policy.
The IRS goes to life insurance if you are the owner of the policy and the insured. So if you are both of those people, so if I own a policy on myself and it names my kids, it ends up right in this gross estate because I'm the owner, I'm the insured. But if I had my mom own the policy on my and it was going to pay to my kids, I'm the insured, but I'm not the owner, my mom is, and I'm not the beneficiary, my kids are. So I've broken what they look for. They look for the two things, the ownership and being insured at the same time. Does that make sense to everybody?
And it's the death value that's included.
Right. So if you've got a permanent policy that's got $50,000 of cash value, but $250,000 of death benefit, it's the $250,000 that they're going to want to pull in because you owned it. That's what they're looking for. What did you own? What's in this gross estate?
But if somebody else owns it, it's not.
Somebody else owns it, it doesn't fall in here because this is just the gross estate of the person who, for life insurance, was the owner and the insured. So if you don't do anything else, when you leave here, make sure you check and see if you're the owner and the insured of your life insurance policies. Because if you are, those proceeds are headed straight into your gross estate for estate tax purposes. Life insurance is always income tax free when you receive the proceeds. If you do it the right way, it's not in your gross estate either, so it's estate tax free. So if somebody else owns the policy on my life and it pays to somebody else, my kids, my spouse, whoever it is, that's not income tax, it's not estate tax, it's just money. So there's a question about what's the best way. Okay, so the best way, if one choice is you have a policy that you're the owner and the insured, that's a really bad choice, because that's where it's going to put you right in here. So the other option is let's have somebody else own the policy. It can be the beneficiaries, which is usually what makes the most sense, is to have, if it's going to pay to my spouse owns the policy and the proceeds go to her by beneficiary designation, and all I did was die. You know what I mean? It wasn't a tax implication to me. The question is Congress still discussing extending or repealing the estate tax? Absolutely. We have a new rule that's effective for 2 years, this year and next year, and the classic political things that we're going to let the next people deal with. So in 2012, it's going to come back up. And we'll talk about what the rules are and how they're going to change, but they're still thinking about it, yeah.
One quick question, then we'll get going.
If you want to change ownership, doesn't that, the value of that go against your minimum, against your $13,000 gift tax?
Yeah, it depends on who you're changing the ownership to.
The beneficiary.
So if you're changing it to the beneficiaries and there's cash value, you have to worry about that. If you're just putting it into your trust and saying whoever's the trustee of my trust, I want them to take care of it, that's okay.
But if you put it in your trust, it's part of your gross estate.
It's still part of your gross estate, but let's keep going through so we can see where we run out of.
10 more minutes and we'll come back for questions again.
Okay. So,
Life insurance.
So we've got life insurance and retirement plans, very possibly going to be part of your probate estate because they don't go into your trust. But we've got the beneficiary designation. And we've already talked about some of the weird things that can go on with these accounts and these policies. So we've got to be careful of those. Personal effects, we already talked about the $3,000, $10,000 rule for the IRS. That's their idea on personal effects, on art, on collectibles, on jewelry, all of those things. They want you to come up with those values. Now the question is, how do you get this stuff into your trust? Nobody has a deed or a title record of who's got your watches or your necklaces or anything. Part of your estate planning should include a very broad assignment of personal effects into the trust.
Please check your living trust to see if you have a general assignment of personal property in your trust agreement.